Welcome to Conveyancing Matters with Lorraine and Stu. Join us for a chat about all things property.
Well, we appear to have lost Michael's lovely face, but we do still have a rather beautiful and enigmatic screenshot of him in the Australian bush. So I'm all for carrying on. So, Stu, what was the next thing you wanted to raise with Michael? Because we know he's there.
A lot of stuff we've been talking about today, I think, will really hit a nerve with some of the guys that are watching these videos, insofar as it seems a much nicer system to operate. But what's really coming across to me, Michael, is that one of the moans I have with the conveyancing system over here is that we're forever getting involved in things that maybe fall outside our remit. So, for example, we may be asked to comment on matters that relate to the condition of the property, such as certificates relating to boilers or windows, things like that. We get involved in tax over here with stamp duty, whereas you guys, it seems it's just that sort of step away and you're sort of concentrating on the conveyancing. So mate, what about surveys, things like that? Do you guys get involved in surveys?
Yeah, we always recommend that any purchaser get a survey of the property to ensure that everything's built within the boundaries, of course. Surveys are quite expensive, maybe $1,000 is the standard price these days for a survey. And a lot of buyers will not worry too much about it if they think the house is built inside the fences. So surveys aren't usually obtained by purchasers, despite us always recommending they do so.
But for us, Michael, over here, I mean, there's, a survey in our sort of parlance, if you like, is very much more around checking the physical structure of the property to make sure the physical structure itself is sound, rather than built within the title boundaries, which are different things. And actually the lenders will always insist over here on a mortgage valuation report, which again just represents, confirms that the property represents good security for the loan. But so are there any checks on the sort of actual physical condition of the actual building on the land?
Yes, indeed, but it's separated out from what we call a survey. We call them building and pest reports, where the purchaser, prior to entering into the contract in the first place, one of the things they do pre-exchange is obtain a building and pest report where they determine the physical condition of everything that's built on the land. And that's because the contract here makes it very clear that a purchaser enters into a contract and on the basis of their inspections and investigations of the physical condition, and that's quite separate to the legal title to the structures on the land. So it's wholly in the purchaser's court to do those prior to exchange of contracts.
That's interesting, because our local search, which is maintained by the local authority, Michael, has a lot of information that you mentioned would go in your upfront contract. I mean, we'd call it a contract pack, I suppose, but it's essentially the same thing. So, telling us about the planning history of the property, telling us about, whether the roads fronting the property are adopted by the local authority and so on. But actually that information, that sort of bled into now having, as Stu mentioned, certificate, electrical certificates that have been sort of certified as as being competent and in compliance with building regulation, and as Stu's mentioned, window certificates to confirm if there's new windows, they're sort of health and safety compliant. And the lawyers over here, with the conveyancers over here, Michael, we've just picked up all of that stuff about, and I go on about it a lot. I didn't become a lawyer to check window certificates, quite frankly. Yeah. With that, and we've just kind of bent over and taken it, really.
Well, we're obliged here to enter a retainer agreement, which we call a cost disclosure agreement. And that retainer agreement does two things. First, it specifies exactly what we're doing on the matter for the client, and you can confine your advice and representation to a very narrow area, which is buying the property and arranging the finance. And that pushes outside of those parameters of that retainer anything like the sorts of stuff you're talking about. And the second thing is it also specifies the costs that we charge, and so the client knows up front what those costs will be. And if the client wants to venture down other avenues, such as tax complications or implications, or anything to do with weird and wonderful things that might fall outside the general purchase obligations, well, then you charge them for it, and you're entitled to do so. So that's why we have upfront a very clear disclosure regime for what we're doing for the client and how much we're going to charge them for it.
I think that leads us into another question, which we can't really not ask. So surveys are expensive, Michael, but what about conveyancing fees? Where do they sit in Australia as a comparable?
Well, perhaps, and also as compared to the agent's fee.
Estate agent, yeah.
Massive disparity over here.
Oh, huge disparity here as well. Agents probably operate at least 10 times what the lawyers and the conveyancers charge. Agents operate on a percentage of the sale price, and we generally operate on a fixed fee basis. Licensed conveyancers generally a bit cheaper, probably about $1,000 to $1,500 for most bread and butter conveyancers, and the lawyers are probably a little bit more than that. But there's huge variations between various parts of Australia. Obviously, the wealthier transactions attract a higher legal costs, and similarly the poor areas, the legal costs are pushed down by the economic ability of those people to afford that. But generally the figures I've given you are a broad range of what bread and butter transactions would be in Australia, and I think it's about 2 to 1 now. There's $2 to £1, so that gives you some sort of form of comparison.
Oh, that's really interesting, because we have the upfront letter which scopes the retainer as exactly as you've just mentioned, Michael, and sets out the fees. The unfortunate thing here, I think, is there has just, and for some reason, conveyancing solicitors, as I've said, have just laid down and accepted it, because there's just been a massive, massive mission creep over here as to what a reasonable conveyancer would be expected to deal with. And of course, if we do, if Stu or any of his colleagues sort of, stuff something up and get it wrong, and they're sued for negligence, that they will be compared with, well, what would a reasonable conveyancer have done in this circumstance? And it just seems to have become the accepted norm, Michael, that we will do all of those other things, and we'll check for, as I said, building, electrical certificates and all of the rest of it, and we've just sort of allowed it to happen. And if I can promise you, if a conveyancer scoped their retainer over here and said, we are going to deal with the legal title and the transfer of money, and we're not going to deal with all of those other things, I don't think they get any work with this, Stu.
Definitely not. I mean, our retainer virtually does say that. It actually explains what conveyancing is, and the remit under which our client instructs us what we are to do. But of course, there's this blurred line as to what conveyancing is and what the moving process is, and therefore who does what, which is always very difficult when you're trying to offer good service to a client, being restrictive at the same time.
It's always the temptation to give them a little bit more in the hope that they'll come back, but sometimes you've got to be pretty black and white with the lines. And here we just tell them, the physical condition of what's built on the land is your responsibility. You go and get a building and best report. Here's the name of someone I know who will do it well. Send me the report when you've got it, and I'll read it for you.
I think one of the differences where that makes it easier for you guys, I think, is the fact that you don't act for the lender. Here we are asked by the lender to check various certificates, planning, building regs, etc., etc. So I think perhaps not acting for the lender does you guys a big favour in that respect.
That's probably right, Stu. I'm pretty sure. Yeah.
It's interesting. I think there are so many features we sort of said offline, Michael, that there are just sort of the Aussie system so far sort of winning in my book. We're going to do this international comparison at the end of our discussions with all of the lovely lawyers across the globe that we're talking to. But I think at the moment, the Aussie system is winning. But I also think there are many, many aspects of your system which, by and large, really describes the conveyancing system over here as it was probably about 20 years ago. And all of this mission creep and all of these additional responsibilities and all of the AML and the lenders and all the rest of it, that's just stuff that conveyancers haven't had the wherewithal or the foresight to push back on, Michael. And another thing, and perhaps one of the, maybe the last things, because I could talk to you all day, I think you're lovely. One of the things that has become a massive feature in the market over here, which I think is a significant sort of fragmentation point really, is there are lots and lots of companies out there now, and good luck to them, I hasten to add. We call them prop tech. Well, young people call them prop tech, Michael. Property technology companies that see a slice of the conveyancing pie, think I want to have a slice of that, and they offer you know, technological solutions to parts of the conveyancing problem as it's perceived, whether it's electronic identification, whether it's you know, apps to, you know, track your transactions, case management systems, whatever. Do you have much of that sort of bleeding into the market over there, Michael?
Yeah, they're creeping around the edges at the moment, but again, a bit like the indemnity insurance, they're not really getting a foothold in anywhere.
And why do you think that is? Sorry to cut across you there, Michael. Why do you think they're not getting a foothold?
I think it's probably because the system is working fairly well at the moment, and at the end of the day, the client gets their title, they get their new loan, and off and away they go. These extra little bits and frilly bits don't really help them all that much unless they can save them time and cost in the conveyancing process, which hasn't really been satisfactory in convincing us in that yet.
That's interesting. I tell you what, Michael, what you need to start looking out for is when people come into the market with products that they describe as game changers. that's the big one. But it'll be really interesting. I'd love to get you back anyway, but I'd love to get you back in about 5 years, assuming Stu and I are still doing this, just to see whether there's more of that going on in your market, because I just think it fragments the market. It means that if you've got, I don't know, how many conveyancing firms have we got, Stu? Is it about 9,000?
9,000, I think, is the quoted figure, isn't it?
Yeah. So 9,000 firms in England and Wales that do conveyancing work. There's some very big ones that have got, you know, clearly a percentage of the market, but you still have, Michael, over here a huge number of smaller organisations, some of which embrace, you know, technology and are fantastic. But when you've got a very fragmented market and lots of people, you know, adopting lots of little different bits of prop tech from lots of little different companies, that leads to fragmentation, not you know, not the other way.
One area which is being transformed pretty quickly in this regard, and that is the process of exchanging contracts. Previously, of course, it was done with a hard copy contract that's signed by the vendor and purchaser, and whether that's exchanged by the agents or by the solicitors, it was always done by hard copy. But very quickly now, there's pressure to have the exchange being done by electronic means, where a PDF version of the contract is signed electronically by the purchaser and the vendor, and they're exchanged electronically. And that, of course, saves time, it saves money, it saves labour, it saves everything. And that is quickly affecting that part of the transaction, the conveyancing process.
Oh, that's interesting, as I say, because we still largely cling on to the hard copy with the wet ink signature. We've got a big debate going on over here, Michael, about you know, the validity of electronic signatures and signatures on contracts and signatures on deeds. That's a thing, I have to say.
Well, that's a concern for us lawyers here, but the market is going ahead, irrespective of that concern. The transactions are going ahead on that basis.
Have any of them been legally challenged yet?
I'm not aware of any court cases that have challenged those yet, but I'm waiting interestingly to hear the first one.
Yeah, I'm just hoping that you or anybody you know isn't the firm that's left standing with no chair when the meeting stops.
So do I.
Oh God, it's me.
I was taught of the statute of frauds very early in my legal education, and it's a very old law and it's a very good law. But...
How funny. Well, they often are, of course. They often are. Now, I was going to ask you something else, Michael. What else was I going to ask you?
I've got one, Michael. Just going back to, we spoke about time earlier. Just dawned on me as we're going through the chat today, that obviously you guys are, you know, compiling everything or completing everything a lot quicker than we. And you might have already said this, and maybe I've not heard quite properly, but when a client actually starts their journey to buying that property, obviously you mentioned that the contracts are drawn up either by a conveyancer or by the estate agent. How much time is allocated to that process and the you know, compiling that upfront information at the onset? Because it suddenly dawned on me that, you know, we talk about sort of an 8-week process when everything's ready. And I always think there's a bit of a disparity here in England, because we talk about things from, you know, when we're instructed, but when we're instructed, nothing may happen for a good month, purely because the clients, for example, haven't concluded, you know, filling in all their forms, or maybe the chain's not even complete. So sometimes I think statistical stuff that we look at is biased, because actually we should be timing it from when we issue a draft contract pack to completion, and maybe we'd be closer to you guys if we did.
Yeah, just one minor correction, Stu, that is the agents don't prepare contracts here, it's either the lawyers or the licensed conveyancers, which is put aside. Yeah, from the moment we get instructions, I can get a contract out generally within a couple of days, as long as I've got good and proper instructions. All of the things I need to obtain for the contract are online, and indeed the most recent contract I issued only took me about 24 hours. Once, of course, the contract's out there, it's up to the vendor and the agent together to market the property and sell it. And of course, if it sells quickly, the 6-week period chimes in. So it's a very efficient process these days with the assistance of the electronic avenues that are available to us. And not a lot of time is wasted if the transaction needs to go through quickly.
Okay. And do you have, we have here sort of what we call protocol forms, which are a property information form, which is just general gumph on the property, you know, sort of what boundaries may have been maintained, whether there's been arguments with the neighbours. We have a fixtures and fittings form, which is what's been left in terms of furniture. Do your clients have to complete those at the onset, right at the start as well?
No, clients don't have to complete anything in particular. The clients, it's up to you, the vendor, the solicitor, to obtain good and proper instructions. It's everything you need to know to act for them in that transaction. There's no statutory forms or other mandated replies that they need to give to us. We just go ahead then and prepare the contract as best we can.
So how does a buyer find out, for example, then, Michael, if, well, as Stu said, if the seller has had a dispute with the neighbour, or a dispute about a boundary, or whether the seller has carried out any sort of alterations to the property? I mean, this is the sort of detail that we get bogged down in, you know, what utility companies, so who provides the gas and the electric and and, you know, is there any Japanese knotweed in the back garden? And that's all standard stuff in our property information form, which the seller completes. But then, of course, the buyer and their solicitor will sort of pick up on and start raising inquiries on. Who occupies the property? You know, are there any non-owning occupiers? So I mean, all of that stuff. I mean, some of it's more relevant to us as land lawyers than others, but frankly, lots of it isn't.
Yeah, that process occurs, but it occurs after exchange and before completion, by way of the purchaser sending a list of questions, which we call requisitions, to the vendor solicitor, and the vendor solicitor will then get instructions on those particular things, such as non-owning occupiers, and, you know, any unknown disputes relating to the fencing or otherwise concerning the property. That's all contained in this list of questions that is sent from the purchaser solicitor to the vendor. But
what if there's an answer in there, Michael, that a buyer isn't happy with? So for an obvious one, I suppose, would be a boundary dispute. It'd be relatively rare, but you don't want to buy a property where the current seller and buyer are arguing about 9 inches of boundary.
Yeah, that's true, but it doesn't arise very often, and when it does arise, your conveyancing matter then goes a little bit loopy until you can resolve it one way or the other. So there are remedies in the contract for those sorts of things, but obviously if something like that arises in one of the answers, that there is some dispute or ongoing litigation affecting the property or whatever it may be, then your transaction then gets into the realms of becoming a very difficult transaction to resolve.
Oh, okay.
Ultimately, it's a dispute then between two contracting parties as to what they're actually conveying. Are they conveying clean title to the land, or title with some sort of hindrance or aberration that they never agreed to supply?
Yeah, it sounds like a bit of a risk-benefit analysis, really, in the sense that it seems that the system over there accepts that very infrequent number of transactions is a price worth paying for the rest going much more smoothly. For almost all of them going much more smoothly, yeah. We don't have very many issues arise
with those sorts of things that cause a transaction to come off the rails.
Gosh, I think we've got loads. We find all this stuff up front, and yet you know, our argument is that all of this stuff comes up front so that we don't have those surprises, but the system doesn't appear to be any more smoothly, and certainly not any quicker over here, Michael. So you did mention right at the beginning of the chat different systems across different areas of Australia. So maybe to conclude our chat with you, is Oz so big that really different localities are just treated almost as different countries, if you like, in terms of conveyancing systems?
Well, they are different conveyancing systems across state borders, and the states operate in their own independent way, and they've got their own practices. Obviously, a lot of consistency, but unless you practice in those states frequently, no one would be comfortable in being able to act in another jurisdiction in another state in Australia. So I wouldn't be going to do a transaction in Victoria or Queensland, although they're nice places to visit, but we keep to our own state because there are differences in approach. I imagine much the same way that you have differences across the various countries of the UK.
But is the land system of land registration and PEXA national? No,
the land system registration is state-based.
Oh, okay.
And it originated by the fact that we were settled by you gentlefolk, and the colonies were set up, and those individual states preceded the Commonwealth. So those systems of land regulation and ownership were set in place on a state-based basis prior to the Commonwealth being formed. And so we have a state-based conveyancing system throughout the country.
Oh, okay, that's really interesting. So, so Michael, come on, let's put you on the spot. The best bit about your process.
I'm really enjoying PEXA because the amount of time I used to spend on public transport going into the city to attend a settlement and then hopping on the train and coming back to my office was just inordinate. Now, I say that somewhat tongue-in-cheek because we obviously engaged settlement agents most commonly to do so, but it was still a very time-consuming process to prepare for a settlement, send everything into the city so all the parties can get together with their various settlement agents and conduct the settlement, and then attend to the registration of documents and so forth afterwards. PEXA, it all happens in one cruel swoop, and it's a very easy system to set up prior to the settlement, and it's over and it's out of your hair. You move on to the next matter very quickly. So that is really a vast improvement to the conveyancing system in Australia.
That's really interesting. And as I say, that instantaneous registration, that's, as I say, a real holy grail over here, isn't it, Stu?
Most definitely. Yeah, that's what we'd all like to see, I think.
Well, because one of the riskiest parts of the transaction over here, Michael, is actually the post-completion work, paying the stamp duty, land tax, and getting the registration done. There's two different deadlines for those, and both have quite significant consequences if you miss them, really, in essence.
Wow. Well, they're all done as part of the conveyancing process, and indeed, the duty and any land taxes paid at the settlement is part of the funds that are transferred electronically across the electronic space.
Yeah, and I say I know the land reg over here have looked very closely at that system, but well, Michael, just a fascinating chat, really, really interesting. You know, so many things to come out of it. And as I say, it's a shame that the Zoom didn't quite manage to hold up across the globe, but nonetheless, we have had that beautifully relaxing picture of you for a while. So
Thank you.
Very, very kind of you to join us. So thanks ever so much.
My pleasure, and it would be enjoyable to spend some time in your office and see how the system works sometimes.
Yes, well, you'll have to. But take care.
Thank you very much.
Take care, Michael. Nice to meet you.
Cheerio. All the best.
Bye.